Miguel?
How many do we have?
Yeah, we only need.
Good morning, sir.
Good morning.
Do you have a lawyer today?
No, sir. No, Your Honor.
Have the ability to hire a lawyer?
I do. The only thing is, they're way more expensive than it would be to just pay off what I owe the county.
I mean, how much is he owe? It's a theft by check.
$141 in the, oh, wait. So one check was written for $1,377.63, and then one was written for $141.13.
HEB?
The tax assessors, Harris County tax assessor.
Okay. I'll give you a lawyer today. That way you don't have to just start wasting a bunch of money. Do you mind appointing a lawyer?
Yes.
So just hang tight. I'll give you a lawyer here momentarily.
Sure.
Okay?
I'll get on
Please.
this time a little bit.
Yeah.
Right this way.
Did you put an offer on the case?
There is no offer on the case
Do
yet.
you mind?
Yeah.
Please. Good morning, Mr. Wilson. Do you have a lawyer today?
She just reached back to me this morning, so she told me she's gonna contact me this evening when she get done with court.
Hired her?
I just got in touch with her. Like, I've been reaching out to her, but she just responded.
Okay. Do you want more time?
Yeah.
Okay. Head on over to Victoria. We'll give you more time. Are you ready?
I just sent you an email on that. Danielle. Yeah. We had addressed it before. Yeah, it was, you sent him to get a drug test on the first BVR. And then it came back positive for opioids, I think. And they said they wanted to send it to a lab. I provided a list of the medications. And then they submitted that second BVR with all that stuff and saying that he did provide his list of medications.
For who?
Janelle.
Oh, is it Montanel?
Yes. Yes.
Is it Montanel?
Yeah. Montanel's master.
Yeah, so we were waiting for the lab results to come back and they have come back.
We knew there was a presumptive positive.
Yes, the presumptive came back.
She's testing positive for alcohol, though, right?
No. Just opioids. It's a he.
Oh, I was thinking someone else. So one of those that she's taking test positive for.
I think several of them do. And just a presumptive look at it, when I first looked at it, it was the antipsychotic ones that would give false tests, as far as that's concerned.
Is there just no one at pretrial that can address
None of
this?
us that go.
Not you guys. I know you, but there's no like.
No, we would have to, not even our drug technicians. I reached out to my supervisor regarding it. And to confirm that, we'd have to get someone who's certified or someone from Abraham.
Okay, I'll speak now then. Let me reply to all you guys, and then I'm gonna bring someone else in as well. Let's see. So I'll send this email and we'll just stay in touch and then we'll see what they say.
Okay.
I'm gonna reach out to the higher ups to see, hey, do we have any? I mean, I can't believe that we don't have anyone that would be able to.
To say one way or the other.
Right,
Yeah.
you know?
I'm trying to pull up the picture I have, but it won't pull up for some reason. But yeah, there are I think one or two of the medications that he takes can give presumptive false positives.
If that's the case, then of course we're not gonna dig in.
Right.
See,
Okay. So do you want to leave them on for Friday or do we want to just hold off?
let's hold off for
Okay.
the original date for now. Let me see what.
See what they come. Okay. All right. Sounds good.
She's already. She can handle. Hi.
Is it going Monday?
Yeah. Apparently you sent my client to go pee somewhere.
She would like to go.
I didn't want to be crass, but that's the fact.
No results of that, Judge. She hasn't provided a sample yet.
We've had a lot of history with her.
I saw that. I got emails on Friday about it.
Had, quite a bit of history.
Third bond violation. I saw that. Do you want me to recite it out of my memory?
That, we've had quite a bit of history. Does she not have a prior case with us too? Is this,
21. I don't think she does.
No, it's just this
is
case.
this the one where there was an issue with a boyfriend and?
There is a boyfriend in the car, and the really interesting thing about this is like the police officers did a full felony stop on a DWI with guns drawn, making them get out. It's kind of weird.
Capital?
It was really strange. I'm watching it going like,
Capital DWI?
That's what it was. Of course, it was like precinct 4-ish. Everything up there could be a capital in their minds, you know? And so I don't know what you want to do with this judge.
Just don't want her using, that's it.
I get you.
That's all I want. I want to ensure that she's not. So,
Judge, and then also we have the English interlock that she's not doing, so we're not monitoring her. By any means, because she had the portable at first, we had portable violations, so then she was revoked. Then she provided proof that she had gotten her vehicle fixed, so we swapped her over to the ignition interlock. The ignition interlock is not being used.
so let's see how it goes today. And then I'm gonna random her again. So, you know, if she tests positive, then we'll see. I don't know.
I mean, do you want me to wait? I'm perfectly willing to do that.
Go, and then I'll get a hold of you. Or you know what? I don't have your new number. Do you mind?
Give me my new work number. My old number is still the same.
Oh, is it really? Then hold on.
You have it for sure.
Yeah, I know. If it's the same one, then don't worry about it.
Yeah, it's the same.
5-6?
I don't give that out to anybody. That's me. That is me.
Okay, so I'll text you. And then
But do you want me to come back if there's an issue?
you can always Zoom.
Okay,
Zoom.
perfect. I'm gonna go straight to my office.
Go. Hi, Joe. How are you?
John was asked by according to Courtroom Espinosa. This is on the docket, DWI case, clients here. We are still waiting to hear about whether PTI is going to be approved on this.
Everything's in, Judge. We're just waiting to hear back about the approval.
Okay. I guess let's give it a week, Joe.
Okay, sir.
If it's approved, I'll waive, and then we'll sit you off like a couple weeks for you guys to get the contract, get the, you know, portable and all that jazz. If it's denied, it's got to be here so it's.
Okay. Well,
Yeah.
thank you.
Okay, for sure. Have fun. Ready?
Good morning, Your Honor.
Yeah. What's up?
I am here on Mr. Mark Gurley's case, who's on docket today, Judge, Gurley. And initially, I'll wait till you find it, Your Honor.
Thanks. Girl?
Yes, sir.
Okay, I see it.
So initially, I had brought up some concerns that I had with the accuracy of the DIMS report and accuracy of the information that was being alleged within the four corners of the probable cause hearing information, I guess. And so you had set
As
this.
far as probable cause?
Right, yeah, as
You
far as
want to
probable.
redo probable cause?
Well, we had heard probable cause, and within the four corners of the DIMS, you had found that there was probable cause for the case to continue. But the issue that I had,
Want to do it again?
well, I mean, I'm just kind of bringing you up to speed again, Your Honor, because I know it's been a few weeks. So the issue that I had raised at that time was I did not believe that that was accurate. The state had conveyed videos to us about, you know, what the officer had seen from the dash camera perspective. And so I had issues with the accuracy of what was contained within the DIMS. I've spoken to the state this morning, and she said that she's reaching out to the police officer to find out, you know, I guess his side of the story is my understanding. I don't want to speak for the state.
I
but-
watched the camera footage. I just want to speak to the officer before we make any decisions on the case.
The issue.
The issue is that from what I can see, I don't want to get into the facts of the case right now in front of you, Judge, too much, but,
Then don't.
right.
Then don't. Just do what you need to do.
Right.
You want, I mean, it's only 25 days old. You want-
Sure.
I just emailed him today. Yeah. I think a
Set it up
regular
a week.
Yeah.
Is
Sure.
that-
It's a very new case. If I can get maybe a couple of weeks, Judge, I've got.
I mean, you can have as much as you want.
Sure.
It's up to you.
Yes, sir.
I guess if you just set it, if you need me to do another probable cause hearing, I'm happy to do it.
Sure.
If there's something that has come to your attention that's not right in the DIMS, I'm happy to hear it and we'll redo probable cause. I'm happy to do it at any time.
And maybe the state's conversation with the officer will clarify all of this and then.
Yeah, absolutely.
All
Okay,
right. All right. Thank you.
I'll grant it for you.
Thank you, Rob.
Okay.
Excuse me. Thank you.
Hi, Judge. How are you?
Ah,
Good to see you,
it's been
Chloe.
such a long time.
I know, I'm back.
What's new?
I have
Thanks for the warning.
kids. How are your kids?
And maintenance.
How old now? How old?
14,
Oh.
12, 9, 3.
There's 12 or 14 girls?
Well, a boy and a girl. We put them to work.
A real girl?
Girl.
God bless you in every way there is.
She's great.
Your life.
I love it. I'd have more if I had money.
Girl, it's just you and
She's so sweet. Great.
we've been there. We were 12-year-old, 13-year-old, 14-year-old girls.
Those was rough for 12.
They're hard.
It's okay.
They come out of it.
Yeah. You just give it time, patience, you know?
I have Miss Cookman, who's not on your docket.
Okay.
She was here on Friday and she's hired me on a DWI and she has 2 trips planned and she has to do UAs. One is out of the country, one is not. How do you handle that?
So typically, if they're out, we have them, if they're in the United States, we have them go to like a quest wherever they are.
Okay,
They get called on to do
Okay.
this. Get the results to you, get to us, we're happy.
okay.
If they're out of the country, how long?
She'll be out of the country for 5 days.
So
Puerto Rico?
let her know,
Yes, or her.
let her know not to use. She's gonna get tested as soon as she gets back,
Okay.
just so that she knows.
Okay. Okay,
So
Perfect.
just let Felicia know about the dates so that for the out of country ones, so they know not to call.
okay,
And
perfect.
then, yeah,
Will
that's
do.
it.
Thank you.
Okay.
Appreciate it.
Have fun. Hi, Shreya.
2-5.
I'm just here for Mario. He's got Christopher Torres, who is surrendering himself today. I believe papers are filed and everything. But he had, and I'm a little unclear on the details because I wasn't here, but he had brought an AA log that I believe you were gonna, if he had shown you that.
Well, no. I said be creative with what, and I would consider waiving the
Sure.
fee.
And so he's given me an AA log. All right, give it to the court all the time, see what's going on. He'd gone almost every day. There were some wildfires that he had to be evacuated from. So that's the only day or a couple of days he
Last name again?
Torres. And Mario's off picking a jury across the street. Otherwise, he'd be here himself.
The reason I had the problem is because he has a prior intox assault where there's like, and now we have another second.
Understood.
So that's the problem I had. And I was hoping more than just 11 classes.
I understand.
Okay, here, let me give that back to you. Christopher Torres, come up. So, Mr. Venus, correct me if I'm wrong.
Sure. Yes, Judge. Yes, sir. Be as much of a help as I can.
On a sentence of 10 years in prison, probated for 10, can that be used on a third degree to enhance to a 15 to life?
If the probation is successfully completed, no, for enhancement purposes. It could be for jurisdictional purposes, to make under 4904 or whatever it is, to make it would count as a previous conviction for those purposes, just like an assault family member, even a deferred adjudication would count to make a second.
My curiosity stems from because with his intox assault, he was sentenced to 10 years, probated for 10 years, and it looks like he may have completed it successfully, but it's still a felony conviction, right?
Correct, but it's not, you can't use it to enhance punishment ranges, essentially. It could be a jurisdictional paragraph, but not an enhancement paragraph, if that makes sense.
My concern, Mr. Torres, is you're now pleading guilty to this DWI second. The problem is that if you pick up another DWI, from now on, you're facing a third degree felony. You're looking at 2 to 10 in the penitentiary. And I don't know if they can use that intox assault conviction to enhance you to an even further penalty, a further consequence. I mean, that's why I'm asking you. I don't know. I know misdemeanors, but the problem is that with a felony conviction, they can use it to enhance punishment. Perhaps it's a 15 to life next time you pick up another DWI. I don't know. But do you want to take that risk? That's the problem. I mean, imagine all this that you've suffered now, and we're here yet again. What's it going to take? A death? Well, I know you say no. Everybody says no. If I had one strand of hair for every time, I'd have a nice looking head of hair. You're facing up to a year in jail and or a $4,000 fine. What are we doing?
Oh, let me get a
You're giving up a lot of rights by entering into this agreement. You give up the right to a trial, right to compel witnesses to testify on your behalf, confront and cross-examine your accusers. If you're not a citizen, there are possible immigration consequences. You can be deported, excluded from the country, denied naturalization under federal law, and you give up the right to appeal. Once you accept this agreement, it will go on your record. It will be there forever. And I'm telling you now, your record, it's not a good thing. You get pulled over, even with the faintest smell of alcohol, you're going to be charged with a felony. Do you understand? I wouldn't, even if you've had a sip of alcohol, I wouldn't get into a car. So, he goes in today?
Yes, sir.
All right, I'm gonna waive the fee because you're going into jail now. So I'm not gonna tack it on, but stop. Don't kill someone. This weekend alone, 3 people died on our roads this weekend. This weekend, 3 people died. It's not hard. Just don't get into a car. How do you plead to the offense? Guilty or not guilty? I'm gonna find you guilty, sentence you to 50 days in jail. I'll give you credit for the 2 days that you've done. I'm gonna suspend your license for 1 year. Do not drive until you get a license, and then we'll take him into custody now, and I'm gonna roll your court costs so you won't know anything, all right? Okay,
you, Judge.
Good luck. Thank you. Thanks for coming. Great to see you, man.
You too, Judge.
Matthew Leonard.
Yes, sir.
So Leonard, you're charged with driving while intoxicated, second offense. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can and will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
Judge, on 4/12/2023, officers were dispatched.
Hey, yo. Hey.
Do not have story about that. Right. On 4/12/2023, officers were dispatched to a crash involving a bus and a car at the 1700 block of Travis Street. Officers made contact with the defendant who was slumped over in the driver's seat of the car. Officers observed the defendant to have red and glassy eyes, strong odor of alcohol in the breath, SS, and slurred speech and incoherent speech. Defendant told officers that he was drinking 211's beer at his house and last drank 2 hours ago. Defendant was taken to the hospital and diagnosed with a minor brain injury. Officers got a blood warrant. There was a blood draw completed at JPC.
Then, so what, do you have the results? Hold on a second, let me see.
No, not yet.
No, Judge, we don't have any blood results
I see
yet.
it.
For some reason, there haven't been any to-dos done on the case. I'll submit them immediately. That's.
Well, it looks like it's because it was a 2B, that's why. So it's from April of 2023. Looks like there was a blood of a 0.198. Okay, Mr. Leonard, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. Because it's a second offense, I'm now ordering you as a condition of your bond not to drive any vehicle that doesn't have an ignition interlock on it. Miss, can you run his license, see if he has a valid Texas driver license, please? Do you have the ability to hire a lawyer, sir?
How much time can I pass this? Because I'm in the process of getting my ID and everything. Because when I got locked up, I didn't have my wallet. They threw it away or something.
Would you like a lawyer, sir? I can give you a lawyer today. Okay. So understand something, Mr. Leonard. I don't want you drinking. I don't want you using illegal drugs. I'm going to randomly test you, and you're going to have. Do you show a Texas driver license?
It's all good.
Okay. All right, sir. So what I'm going to have you do now is I'm going to have you sign a bunch of paperwork with Victoria, Fleischer, and then I'll have you meet with the lawyer here momentarily. Okay?
Yes, sir.
Please. All right. Good morning, Mr. Hunter. We're bringing you back because you now have a new fugitive case and you have a new lawyer. What would you like?
No, we're seeking fugitive bonds on these matters. The new matter, to the best of my knowledge, this from North Carolina, is basically the same complainants of the Houston case. Same folks. I think their surname is Beaker. I think a $30,000 set in the case here in Harris County. We would respectfully request bonds in the amount of $20,000 on the 3 fugitive warrants. And let my client sort things out with those other jurisdictions as well as ours.
Your Honor, because of the fact that he has now 3 fugitive cases in our court, 2 out of Knox County, Tennessee, and now a new one out of North Carolina County, we'll be asking for no bond.
I told him beforehand, we've visited this issue before, and I told him the last time that he was here that I wasn't going to give him one. He just got way too much baggage. And it's all the same thing where it's a theft from an elderly, and we have the same thing that's occurring over and over and over. You know, and it scares me that if we let him out, is he going to pick up a 5th case, you know? Or it's so much baggage. He scares me, you know?
And he does have He's kind of been a resident of this area, you know, for 25 years. So,
I get it, but he's got a lot. He's hopscotching with the states as far as criminality, right? He's got 2 cases in North Carolina, or 2 in Tennessee, 1 in North Carolina. Now he has 1 here. He's got, in 3 different states, he's got charges. It's too much. And I think that because of that, he's a big flight risk, and I don't want to lose him. You know, and he knows this because I've told him this before. You're not the first person that has approached on me with this. You know? So yeah, it's just, you got to understand that there's a lot that comes with this, right? If it was 1, perhaps, right? But you've got 3 in 3 different states. It's way too much. You know, at some point, it's got to stop. Now's that time. So the idea is that has he made bond? He hasn't made bond on the cases upstairs, right? So because you have not made bond, the 14 days here that would normally kick in is told if and until that hold upstairs is released. So if you're able to make bond on that theft case upstairs, that would kick in the 14 days for those states to come get you. And then they would have to battle it out as to who comes and whatnot, and, you know, so I guess just let me know what you guys want to do. The felony court is set for March 11th. Typically what we do is we just set it the day after. And I'm sorry, Mr. You know, but it's just too much. Yeah.
Your Honor, I do also want to add, he hasn't waived on this new North Carolina case, so he wants to start that clock today.
And I'll let you guys see if that's something that you want to do. You know, if not, we can go ahead and get a governor's warrant. That'll take 90 days. But, you know, if you post bond on the case upstairs, that would get the ball rolling really, really quick.
Right.
So, okay. You guys let me know what you'd like to do. Thanks. Hi. Hey. Happy Friday, man.
Happy Friday. We are here.
Who do we have here?
We have Herman Riley, Judge, R-I-L-E-Y.
Good morning, Mr. Riley.
Requesting bond.
Okay, Mr. Riley, I've never met you before. I don't know you. I got to get to know you in the short time that we have here to see who are you? Are you a danger to our community? Well, everybody tells me that, right? Hold on. I know that you have a statement that you want to say, but what really matters is the paper, because that really tells me who you are. I get people that try to sell me the sun, moon, stars, everything here, but that really tells me who you are. So, Dave, let's get to know Mr. Riley.
Your Honor, he's wanted out of Louisiana for domestic battery involving child endangerment and theft, but the theft is a misdemeanor, so he's only being extradited on the domestic. It was where he is alleged to have bitten his live-in girlfriend in front of a shared child and a second child, a 4-year-old and a 7-year-old. The warrant was issued on May of last year, so we're getting close to a year, Judge, for the.
So he's been on the lam, you're saying, for a year?
Well, I don't believe it's an FTA. I believe it's a 2B warrant.
What's a 2B? Okay.
I don't show any other history, and so state just requests that a sufficient bail be set, but I don't know of his ability to.
So you're okay with the bond?
I'm okay with a bond. I'm not okay with a low bond.
Judge, my client has requested that he address the court.
Yeah, I know.
So let's not talk about the case, because you have the right to remain silent. Anything you say can and will be used against you. You got to understand that I have a ton of prosecutors here. Whatever you say, they're going to sit there, type it down. It's very possible it may get back to the prosecutors in Louisiana somehow. So don't talk about the case.
Myself.
My only concern is, you know, if I set you a bond, number one, are you going to be a danger to our community? Number two, are you going to go back to Louisiana? Those are the main and primary concerns.
That's what I want to assure you of. Okay, right now I'm working. You know, if I stay here 14 days, I may lose my job. I pay on child support and everything. I talked to the bondsman in New Orleans already. You know what I'm saying? So as soon as I go up there, he gonna walk me out. You know what I'm saying? I'm gonna take care of the bonding and everything. But I just want to let you.
It's set there.
I'm checking that right now, Judge. No, there's no bond set, which means they'll set one as he self-surrenders, but I don't know what they would set it at.
So typically the way it works is if we set you a bond, Give you 14 days from the date of your release to go turn yourself in to Louisiana. If you fail to go do that, you have to understand that there are serious consequences. I will revoke the bond, set it at 0, and I'm not going to give you another one. I don't care if you're kicking and screaming and Jesus told you to do something. I don't care. We give you one shot to go turn yourself into Louisiana. You understand?
Yes, sir.
Okay, so let's talk about a bond amount.
Your Honor, due to the offense and the fact that 2 minor children were present and the age of the warrant, is that state requests a bond of $7,500.
Well, Judge, we'd request a bond set of 1,000.
Big difference.
It's pretty big divide, Judge.
So the problem is also is that because you're a fugitive, right? You are an inherent flight risk. So the normal 10% that one would have to pay to typically bond out usually does not apply in fugitive cases, as far as I've been told. So you will probably have to pony up 100% of the money to be able to bond out on a fugitive case. So I guess speak with him, let me know, what's something that you guys.
He told me he could make $1,000 bond.
Yeah, I think 1,000 is too low.
That's the amount that he can make.
That's too low. I mean, that's what we do on normal cases, not just,
Unless I get new information, Your Honor, just again, due to the age of the warrant and the fact that there were minors present, is unless I get new
I
information.
don't want to keep you, right? But I have to make the bond sufficiently high so that I know that you're going to go back, right? What I'll do is I'll set your bond at $2,500, okay? And then just let me know, what we can do is, has he already waived or no?
No, he has not.
Have able to reach out to your folks, your family, to see that's something that whether you guys can make it. And
Under 2,500.
this is not I'm not going to negotiate with you, dude. This is just that 1,000 on a fugitive case with this type is just too low.
And also, just reminding counsel and the court is that even presuming that he's able to make this because Louisiana has set at no bond for him to return and go back to work, he has to make a secondary bond there. And if this is the maximum he is able to pay, then effectively he'll be held in Louisiana and he won't be able to return.
I'll also have to take that into consideration.
Judge, my client has chosen to not take the bond until, if that's okay with court.
2,500, like,
Don't argue with it.
no, okay, no, I'm not arguing. I just want
Here, look, let's do this.
to lose my job and everything.
Let's do this. Let's do this. I'll let you guys go back there, talk about what you can make. 1,000 is just too low, but I'm willing to work with you because, really. But you guys, no, let's not do it here. Go back there, talk,
I'll stand down, Judge.
Christine?
Thank you, Judge.
Thank you, Dane. So Mr. Schreiber's on bond for a harassment case. He's now picked up a new case.
Yes, sir.
You now stand charged with the offense of assault of a family member. You are facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one will be appointed to you, sir.
On January 31st, 2025 in Harris County, Texas, officers responded to a family disturbance call. Upon arrival, officer met with the complaining witness, who stated that she and the defendant are married. Complaining witness stated that the defendant had arrived home drunk and that she hid alcohol from him, leading to an argument. The complaining witness stated that the defendant then grabbed her by her hair and pulled, causing pain.
Is this the same complaining witness in the harassment case?
No, Judge, this is going to be the defendant's wife. I've since spoken to her today back in the witness room.
Who is the
So
complaining
my
witness in the
understanding
harassment?
that in the harassment, it's a neighbor, and then we now have the wife as the complainant.
Judge, if I may, then you may remember the old case. It involved a family that lived about 0.8 of a mile away and involved a dirt
I
bike.
don't remember anything.
And as a practical matter, no, it isn't a neighbor. It's a person who lives in the area. They don't, live next to each other. After this incident happened with the harassment case and his wife is here in court, Mr. Schreiber's now enrolled to go to a facility called Mallard Lake. It's a rehabilitation facility that addresses alcohol problems. He's going to be enrolling on Sunday. And they've sent the enrollment paperwork to my office yesterday. We are hoping that we can reset these cases to allow him to attend that. That is an inpatient program. We don't know how long he will be there, but I would anticipate it's going to be not less than 14 days. But of course, it's one of those things they'll judge his success as he goes.
I am all for it. But you picked up a new case while you're on bond. I'm not going to let you go. I'm not going to give you any preferential treatment. You have to abide by all the rules, regulations as well. And when you pick up a new case, there are consequences. You're old enough to know that. You know, when you have actions, you take the wrong action. There are no mistakes in life. They're actions. And when you take the wrong actions, there's serious consequences. I'm now revoking your bond on the harassment case. You're staying with me. You know, now, hold on. I'm not done with you. I'm also ordering you now not to consume alcohol, illegal drugs, and I'm going to put a monitor on your ankle so I know that you're not consuming.
So I still gotta go to rehab?
Then we'll talk about that.
We'll work through all the, I guess, all the issues as far as there, but I'm not going to take your word for it that you're not going to consume. I need more concrete evidence. And the way that I do that are with these devices, you know, and you're now with me, absolutely no tolerance. If I find that you're now a further danger to my community, I'm going to go nuts on your bond. Do you understand? So what does wife want? Does she want to continue to have contact with him?
She is here to ask that the court modify the conditions of the magistrate's order for emergency protection. Since this incident happened, Mr. Shriver's been living in a hotel. They've abided strictly even with their communication and transportation today with the no contact. However, she is asking that we remove that restriction and instead go with the no threatening or harassing communication.
I've spoken with her and confirmed all of council's represented, and you know, we're not going to be unopposed. We're not going to be opposed to modifying it to no threatening or harassing.
So you have an order for protection that's been put in place by the magistrate. I'm leaving everything in that order intact except for one thing. Well, I guess two. Does the MOAP also say no contact as well?
It says no contact and don't go to their.
Got it. Okay, so I'm going to modify two things. The first thing I'm going to do is I will take off the residential restriction. Number two, I'm ordering you not to have any threatening or harassing contact with the complaining witness in this case. You need to understand what is threatening or harassing doesn't matter what you think. I could give a rat's behind what you think. It's what she perceives. So if I go like this, is that threatening or harassing? It most certainly is, and it can land you in custody. And I'm going to tell you now, any more issues?
That's why I'm going to rehab, sir. Yes, sir. I understand.
You know, there are people in life when they drink, they're very happy, they're the life of the party. And then there are people who develop horns when they start drinking. If this is you, there's one easy solution. So what we'll do is I'll put the monitor on him. I'll waive the fee. Okay. I guess, correct. No alcohol, no drugs, random testing, no weapons, no threatening or harassing contact with the complaining witness, the scram monitor, waive the fees. Get with me as far as the facility and what they say about him having the device on and if they're okay with it, if they're not okay with it. If they're not, then we can work something out. But the minute he gets out, the next day he's got to get the monitor on if they have a problem with it. And then you must charge this device every single day. If the battery goes dead, so does your bond. Do you understand? All right, so I'll set the new bond at 5,001 on the harassment case, and then we're done. All right, goes with you. Okay, Mr. Downey, so just
We'll get a reset, maybe 45 days out. Should give us enough time.
Do that. I need proof though. Like, get me proof that he's actually enrolled and how long he's going to be there. On the harassment case, he's going to make bond. They'll give you a 7-day setting on that afterwards. Feel free to get with Victoria so that way you can match up the date after you get the new date, and then
I have the paperwork. How do you want me to get that to the court on the?
If you want to email it to us, it's okay. Email.
Okay.
It's probably the easiest. That way you don't have to come in and waste time.
No problem. Yeah, I will get it to you right now.
And then just one more thing, always just CC Sebastian. That way they always have it as well.
Okay.
No problem. Okay. All right, guys. Mr. Castillo, you're charged with theft. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On January 31st, 2025, an officer was working an extra job at Home Depot and was alerted by the loss prevention officer that the defendant had entered the store, putting multiple power tools in a basket, and exited the store with unpaid merchandise inside the basket. The officer was sitting in a motor vehicle and observed the defendant exit the store beyond all points of sale and head north in the parking lot. The defendant entered apartments across the street. The officer observed the defendant pushing baskets and approached the defendant. The defendant attempted to flee. The officer deployed a taser and placed the defendant in custody. The total value of items stolen was $519.98.
All right. Right, Mr. Castillo, I'm going to find that there's probable cause to go forward with the case. I'm ordering you now not to go back to any Home Depot. Do you understand? If I find that you do, I'm going to revoke your bond, put you in jail. No more PR bonds for you. You mind filing that, please? Okay. Tell me, do you have the ability to hire a lawyer, sir?
Yes, sir.
You don't want to apply for a court appointed? I don't want to talk about the case. Do you want a court appointed lawyer?
I mean, I could get one, but if I hire a lawyer, then I don't need the lawyer you're gonna give me.
Sorry?
I'm gonna go ahead and get a lawyer for myself.
You don't want a court appointed lawyer?
No, sir.
Okay. If you have a problem and you're not able to, just come back, let us know, and then we can appoint your lawyer. I'm going to have you sign a receipt of Victoria. I'll have you take a seat in the jury box. Let me get your bond conditions ready. We'll have you sign it, and after that, you'll be free to go.
Thank you, sir.
Don't pick up any new cases. Behave yourself.
Yes, sir.
You understand?
Yes, sir.
Okay, man, come on. Ms. Gray, you're charged with driving while intoxicated. You're facing up to 6 months in jail and or a $2,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, ma'am. Okay.
On January 31st, 2025, at approximately 1:34 a.m., officer observed a vehicle fail to signal a lane change in Harris County, Texas. The vehicle also had unconfirmed insurance. The defendant was later ID'd by Texas driver's license, and upon contact, the officer observed slurred speech, red bloodshot eyes, and a strong odor of alcohol emitting from the defendant's breath and person. The defendant admitted to consuming 3 beers. SFSTs were conducted. 6 out of 6 clues were observed on the HGN. 6 out of 8 clues were observed on the walk and turn. 3 out of 4 clues were observed on the one-leg stand. The DIC was read to the defendant, and the defendant refused a breath sample. A blood search warrant was signed and executed.
What did you say the stop was? I missed it.
The stop was for a failure to signal lane change, and then the officer ran the plate and saw that the vehicle had unconfirmed insurance.
Okay. Ms. Gray, I'm going to find that there's probable cause to go forward with your case. I'm ordering you now as a condition of your bond not to consume alcohol, illegal drugs, or unprescribed controlled medication. I'm going to randomly test you. If I find that you're consuming alcohol or illegal drugs, I'm going to put you in jail.
Judge, would you consider an analog for this case?
I am, because she just had one that was dismissed. So I am now placing a restriction on your license. You're not allowed to drive any vehicle that doesn't have a guardian interlock on it. If you're caught driving a vehicle that doesn't have one, I'm going to put you in jail. Do you understand? Hey, you have a great lawyer listed to Mr. Darvish, and he'll tell you when you have to come back to court because you have a lawyer. I will waive your appearance, but it is your responsibility to stay in touch with him. Do not pick up any new cases. Don't drink. And if you lose your license between now and then, you're not allowed to drive. Do you understand?
I do.
Right. The other thing is also a condition of your bond is you're not allowed to drive unless you have liability insurance in your name. Do you understand? So if you drove here today and you don't have liability insurance, you can't drive. You understand?
I do.
All right. So I'm going to have you sign a receipt, Victoria. We'll have you get Fleischer for your bond conditions, and then you guys are free to go. All right. Thanks, guys. Good morning, Ms. Moya. Oh. Do you speak English or do you need?
I speak only English. Yes, only English.
You speak English?
Yeah, only, yes.
And you're charged with interference with the duties of a public servant. You're facing up to 6 months in jail and or a $2,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you.
On January 29th, 2025, an officer was dispatched to a Valero parking lot for a suspicious motor vehicle that may have been stolen. Loss prevention on the motor vehicle came back to the license plate, on the motor vehicle came back to a white Ford F-150. The vehicle identification number on the vehicle was different than what had returned. The defendant got out of the suspected motor vehicle and the officer was performing a felony stop on the possible stolen vehicle with multiple items in her hand. And the defendant refused to obey commands when told to drop them. The officer stated that he told the defendant to face away from him and walk backwards with her hands up. The defendant refused to obey commands and walked towards the officer with her hands down and facing him. The defendant kept moving back towards the front of. The defendant kept moving hands back towards the front of her body while the officer attempted to put on handcuffs on the defendant. The officer ordered the defendant to walk towards the patrol vehicle, to which the defendant refused and had to be escorted by force. The defendant kept moving her hands away from the officer and he attempted to handcuff her again. The officer had to take the defendant to the ground due to the defendant attempting to free herself. The defendant continued to move around so she could not be handcuffed.
Is she the driver or the passenger? Is there a co-defendant? Did someone else get the UUMV?
It does not appear there's any co-defendant.
It's a passenger.
Stop. Ma'am, don't.
All it says is that she got out of the suspect vehicle.
Ma'am, I'm going to find that there's probable cause to go forward with the case. If you do not have a Texas driver license, you are not allowed to drive. Do you understand me, ma'am?
Yes, sir.
Also, you need liability insurance if you're going to drive. If you don't have either, then you're not allowed to drive. Do you understand? Do you have the ability to hire a lawyer or would you like a court-appointed lawyer, ma'am?
Court-appointed lawyer.
Okay, I need you to, let me see if I have an application. I need you to fill out an application for me. I'll take a look at it and then we can appoint you someone later today. Do not leave until you sign our bond conditions though, ma'am.
Yes, sir.
All right? Okay.